He is well known for many things. His intellect, his very sharp writing style, his magic tricks, his accent, and his good sense of humor.
Good looks.
Yeah, and good looks.
Good looks. I can't go through the whole list of the things he's done. But best of all, he's known for his strong sense of justice. And that comes through in his written opinions. His written opinions are so persuasive and well-constructed that they often reverberate beyond his jurisdiction in the Ninth Circuit. Last December, he shook up the legal world in a case that Sidney mentioned called United States versus Olson. I'm just going to read a short snippet from that case. This is Judge Kozinski. He said, "I wish I could say that the prosecutor's unprofessionalism here is the exception, that this prosecutor's propensity for shortcuts and indifference to his ethical and legal responsibilities is a rare blemish to the core of prosecutors around the country. But that would not be true. Brady violations have reached epidemic proportions in recent years." Now, just with that one paragraph, the judge started a national conversation on the subject of prosecutorial misconduct because editorial pages, including the New York Times, quoted the judge and started talking about, do we have a problem in this country with prosecutorial ethics? He has spoken here at Cato many times, and we're glad to have him back. Would you please welcome Alex Kozinski?
Thank you, Tim. Always a pleasure to be here at Cato. Before I start on this subject and this book, I do want to tout another publication, and that is a piece that my law clerk, Misha Seiklin, and I wrote for Cato. And I think, Tim, you were the editor of the book. It's called "You Too Are Probably a Federal Criminal." And it picks up on Tim's point, which is that, in fact, there are so many laws out there, and many of them are so ambiguous, that chances are very good in something you have done in your life. If the federal prosecutors knew about it, they could and they can find out a lot of things nowadays using electronic data searches and so on. If they really want to focus on you, they can probably get you. And they could probably have you behind bars in very little time. So this is a danger. This is the background to the point that Sidney is making. I think Sidney and Ron also acknowledges that point, the very strong power of prosecutors, and for them to take this large body of law, this somewhat amorphous body of law, and go in for reasons that may be good or may not be good, and focus on a particular individuals. And that is a serious danger. Now, let me now talk a little bit about Brady and other kinds of prosecutorial misconduct. I think it's important because I think we have both lawyers and non-lawyers in the audience to understand the significance of Brady. Brady is a decision by the United States Supreme Court, and the Supreme Court has come up with many decisions, Miranda, Brady, in terms of procedural protections for criminal defendants. And, people sort of think they're all equal. I would suggest that Brady is uniquely important because Brady, unlike Miranda, where the defendant may confess and then he wants it suppressed, but he probably did it because he confessed to it. It's a procedural rule, but Brady truly protects the innocent, truly protects people who have been charged with a crime, but where the government has in its possession evidence that if put before a jury would raise a reasonable doubt. And the reason the government has this evidence is because they have such an advantage in gathering the evidence. They know about the crime or they know about the investigation, if it's a white-collar crime, long before the defendant knows that anything is going on. They have access to witnesses, they have access to electronic records, and once, or if it's a violent crime, they have control of the crime scene, and by the time the defendant finds out about it, that there's an investigation going on, the crime scene has been cleared, and whatever there was there to pick up is in the government's possession. So it's extremely important. It is vital for the government, if it has evidence that's exculpatory, for it to give it up and make it a fair fight. Nobody is saying people should be allowed to go free who are guilty, but surely if the government knows of a piece of evidence that contradicts what their star witness says, it's only fair, it's only appropriate not to send somebody to prison without having the jury consider both sides. We believe in juries. We believe in 12 people acting together and thinking together, considering all the evidence, and then if they find somebody guilty, then beyond a reasonable doubt, then we can have confidence in it. But they are not given the evidence. They're not given the exculpatory evidence that's in the government's possession. They can't make, it undermines their ability to make a fair decision. So this is incredibly important and terribly vital to the operating of our criminal justice system. I would say so our faith in the system, the faith that Ron has expressed, that I share, and I think Sidney shares, is based on the idea that we can actually have 12 people get all the facts, all the evidence, good and bad, and then make a fair decision. And then we have the burden beyond a reasonable doubt for the government, which is high, but not insurmountable. And we are then confident that those 2 million people that we now have in jail in our country, 2 million people have in jail, that they all belong there. Once the government withholds evidence, once the government willfully withholds evidence that's exculpatory and gets a conviction, then we can no longer be confident. Now, here's the thing about Brady. How do you know that the government has exculpatory evidence? In most cases, there might be exculpatory evidence, and I agree with Sidney, I agree with Ron. I think most prosecutors, especially most federal prosecutors, are upright, and they do not, and this has been my experience, they do not want to get a conviction for somebody without a fair hearing and without a true finding of innocence. But there are always people out there who want to get ahead by cutting the corners. And of course, it makes it harder for the honest prosecutors because the ones who cut corners then get promoted, they get the kudos, and that creates us an incentive to cut corners too, because after all, you have your own career to think about. So it is exceedingly rare to find out that Brady evidence, exculpatory evidence, has been discovered. It's important to talk about these two cases that Ron has mentioned, and Sidney to some extent, and look at what happened in those cases and what the reaction is when the evidence is found. Now, in the Ted Stevens case, nobody has said this, but this is not a case where the Justice Department came forward and said, whoops, we goofed, we had exculpatory evidence, we're going to present it. An FBI agent blew the whistle. We had a whistleblower, an incredibly rare event, where the FBI agent risked his own career by pointing the fingers at Justice Department prosecutors and says they knowingly withheld evidence. And I hope you will read the book and find out, and I don't think Ron disagrees with this, was a huge miscarriage of justice. Senator Stevens should never have been indicted. He should never have been convicted. He should never have lost the election. There's just no doubt about it. There's no doubt about it. If all the evidence had been available to the defense, that case would not have gone to trial. Just read the book. There's no dispute on this point. Now, the Justice Department, when they found out about this, you would think they would run away and hide in shame, that they would say, oh my God, what did we do? And if the Attorney General at that point had decided to dismiss the indictment, I'd be really impressed. But instead they stood up in court and said, no big deal. They said, no big deal. This was found out after Senator Stevens was convicted, and they wanted to hold on to the conviction. They didn't say, oh my God, this is a horrible thing that we've done. We are so sorry. They said, no, we want to hold on to the conviction.
Different attorney general, right?
It doesn't matter.
Well,
we're not accusing administrations. We're accusing the Justice Department. I don't care who the Attorney General was. The point is the Justice Department lawyers, Justice Department said, we will hold on to the conviction. It was only after Judge Sullivan ordered an investigation and it came out that, in fact, this was huge misconduct that the Attorney General decided to dismiss. I'm not that impressed, I must tell you the truth, because at that point, it was unthinkable that Judge Sullivan wouldn't have dismissed the indictment. There's no doubt about it. And I certainly commend the Attorney General for doing it earlier, but I would have been far more impressed if after the case was indicted, those who were responsible had been disciplined. Didn't happen. Nobody got fired over this. There were a few suspensions, but given the enormity of what happened, this was hardly a slap on the wrist. And now in the Brown case, I'm not going to talk too much about it because what I want you to do is I want you to get the book and look at page 404. Okay? This is the evidence that was produced accidentally by the Justice Department, and it shows highlighting. Now, this was not highlighting that Sidney put there. This was highlighting that was there when the evidence was given to her. These are statements by witnesses that go contrary to the evidence presented by the government. They knew about it. This was not an accident. Somebody went through and highlighted it. And what happened is there was not ever a finding that there was no misconduct. What happened in that case is the court said, well, it wasn't a big a deal anyway. And what they did is they simply refused to reverse the convictions. It was not a case where they failed to find, where they said this was okay. It was okay to withhold. They just said it was not prejudicial, which is what courts do all the time. It's what many of my colleagues do all the time. Let me tell you, just take one more minute to tell you about a case that I had about 10 years ago. It was called Ramirez-Lopez. And what happened in that case is the government had 10 or 12 witnesses who had been brought into the United States illegally. And some of those witnesses said Ramirez-Lopez was the guide, and some of them said no, it was somebody else. And the government, what they did is before there was even a defense lawyer involved, they deported most of those witnesses before the defense lawyer could even talk about them. And the case came to us, and I was flabbergasted. How do you go deporting witnesses? If this were a corporation and they started deporting witnesses in a criminal investigation, you would have them indicted. But the prosecutor said it's perfectly fine. Send back the witnesses before there was even a lawyer appointed for the defendant. So the case came up on appeal to us. Two of my colleagues, fine colleagues, whom I dearly I respect, affirmed the conviction. They said it's perfectly fine. It wouldn't have made any difference anyway. I heard a dissent that was so blistering. It was so painful, so excruciating, that the government then filed a petition for a hearing. Usually it is the losing party that files a petition for a hearing. In this case, it was the winning party that filed a petition for a hearing and asked us to dismiss, to reverse the conviction, to vacate our opinion, reverse the conviction, and send it back so they could dismiss the indictment. I will take my 2 minutes to tell you the aftermath. 10 years later, I get the same case out of the same district. Exactly the same thing happened. They deported the witnesses. So I'm standing there and I asked the lawyer for the government, what happened? Do you remember Ramirez-Lopez? I think you yourself argued the case. They said, well, that case was vacated. It has no presidential value. This is not a joke. This is not a joke. Their view was if we didn't enter an order telling them they've got to do this, they had no sense of responsibility. They did it again. So we had to write an opinion saying, by God, you know what we said there when we vacated the opinion at your request is that you don't do this again. The fact of the matter is, lawyers who want to go bad will continue doing it unless judges do something about it. Now, fortunately, judges are doing something about it. There's a case out of the D.C. Court of Appeals called Vaughn versus the United States that I just came across, and they cite me, so this must be a good opinion. And they specifically direct the trial judge to enter orders compelling the government to meet its Brady obligation. And then in Mississippi, a district judge by the name of Neil Biggers recently filed an opinion where he dismissed an indictment because of Brady violation. It is rare. It is far too rare. These things don't come up often enough. We don't know of all the Brady violations. And if judges and prosecutors, including their supervisors, don't take really stern action when it does happen, it comes to light, I think we cannot have confidence in our judicial system. Thank you.
Okay, before we open it up and take your questions, I'm going to give Sidney Powell just 2 or 3 minutes if you wanted to respond to anything that's been said, and then we'll take your questions.
Just a few points. One of the biggest problems with Brady violations is a defense lawyer does not know what he does not know. There's simply no way to know it because only the government does. So it makes it extremely difficult to uncover a Brady violation in the first place. As additional evidence that the government still didn't get the message with the dismissal of the Ted Stevens indictment by Judge Sullivan, I need only point you to the decisions of the Ninth Circuit in United States versus Cott and United States versus Coring, 2 cases arising out of the same prosecution using the same witness where the same prosecutors, for the most part, did not provide the same evidence to the defense that they hid also in the Stevens case. And there, the government refused to dismiss the indictments against Cott and Coring. They persuaded the district court judge in Alaska that it didn't matter in those cases because there was so much other evidence. It didn't matter that they had hidden the evidence of that completely undercut the government's primary witness. And the district judge agreed with them, like our district judge Ewing Werlein did in Houston. The Ninth Circuit reversed, unlike the Fifth Circuit, and said, yes, it certainly did matter. And Judge Betty Fletcher wrote a blistering separate concurrence that said the government's unrepentant attitude is completely unacceptable, and she would have completely dismissed the indictment. The majority of the panel simply remanded it for a new trial. And I think, I'm not sure what happened in both cases. I think they might have entered pleas to substantially lesser offenses. But no, I don't think the Justice Department learned anything from that. I can also tell you that the government is still trying to alter the ethical rules in all the states to include what's called a materiality requirement, whether the evidence matters or not to the defense, in their initial determination and their ethical obligation as to whether they have to provide evidence or not in the first place. And if they're allowed to decide what matters to the defense, we are in very big trouble, because to them, anything contrary to their view is said with a wink or a nod. They literally use that language both in Stevens and in the Merrill Lynch cases. If the defendant said something that's completely exculpatory, or other witness did, it was said with a wink and a nod, or in the Stevens case, to cover his ass, it wasn't really true. And anything inculpatory, of course, works to their benefit. So everything works to the government's benefit, thereby it's not material to the defense. So we've got to have ethical rules that require production of all evidence favorable to the defense. That's another reason why we need the Prosecutorial Integrity Act enacted to produce all evidence favorable to the defense. The Supreme Court has said that if the prosecutor has any question at all about whether he should produce it, it should be produced. If you even have to ask the question whether it should be produced, it should be produced. Just give it to him. That's the only way to ensure the trial is fair. In terms of the credibility or accuracy of the materials in my book, I'm uploading all the supporting documents to a website called license2lie.com, and you will be able to look at the actual documents themselves. And if we could get a full investigation ever in the Brown case, like they did get in the Stevens case, which Judge Sullivan ordered just terrorizing the department with the fact that an independent investigator, a special